Hello again. There's growing concern about judges that have delayed handing down judgments. Recently, Ground Up has reported that some of the judges have failed to make a ruling on urgent matters and in some instances taking a full year after reserving a judgment. We're now joined by Research and Advocacy Officer at Judges Matter Mbekezeli Benjamin to weigh in on this matter. Mbekezeli, thank you very much for your time. Perhaps let's start with the announcement by the presidency today that Madam Justice Mahube Molemela has been appointed President of the Supreme Court of Appeal with effect from the 1st of June. A welcome move?
Yes, it absolutely is a welcome move, Dudu, and good afternoon to you and to the viewers. Justice Molemela has been one of the leading lights in the judiciary. She comes with a lot of experience as a judge, but also as a leader in the judiciary, and so she would be a good addition in the leadership in the judiciary as a collective, but particularly at the Supreme Court of Appeal, where we have seen in recent times there have been concerns about the performance of the courts in terms of administrative issues. We've heard complaints about how some of the appeals have been not been dealt with as quickly as possible because of administrative issues. So we're looking to her to get down to those issues and make sure that the Supreme Court of Appeal still holds the very high esteem that it still holds in the profession and the judiciary as a whole.
What are administrative issues?
So one of the big administrative issues has been, there is a registry at the Supreme Court of Appeal, and for a while that registry unfortunately has not been performing optimally. So we've heard instances at JSC interviews where the judges have reported that the appeals have gone missing, documents have been misplaced, the lawyers and the parties have not been communicated with timeously and professionally. So those are some of the administrative issues that have very little to do with the judicial function, which is deciding on cases, but it does have an impact in terms of how smoothly the court operates. So that's just one of those administrative issues.
Sure. There are also other concerns about judges, especially in terms of the late delivery of judgments. Typically, how long should a judgment, or what is the time frame of delivering a
judgment? So in about 2014, Chief Justice Mahube enforced a new code of how the courts should perform their functions, and this is called the norms and standards of judicial performance. And those norms and standards say that a judgment must be delivered within 3 months of the date of it being reserved. So in most civil cases, when a judgment was reserved, let's say on the 1st of March, by the 1st of June, that judgment must be delivered. But we also understand that there are certain cases or certain courts where there is really a large volume of work. And so there is a bit of an allowance that a judge may take a little bit longer, maybe 4-5 months. But once it hits the 6 month mark, then it becomes a problem. So generally, it should be 3 months, but it can take a little bit more depending on the circumstances.
What seems to be the problem? What is the delay?
So there are a number of causes of delays, one of which is some cases are very complex. So they require really deep research before the judgment can be delivered, and we know that there is not enough research capacity. So for example, in the Pretoria High Court, there are about 42 judges, but only 6 researchers that work for those judges. If you compare this to the Constitutional Court, for example, each one of the 11 justices of the Constitutional Court has 3 researchers allocated to them. So you can see that because of those kinds of issues, there might be a cause in the delay. But also the other factor is just the volume of work, right? There aren't enough judges, for example, in big courts like Pretoria, the Western Cape, the Labour Court, and those cause a delay because at one point a judge has to be dealing with a complex criminal matter. The next week he's dealing with a family law case. The following week is dealing with a big civil law matter. And so because of the complexity of the work and how little time there is, it ends up the work builds up. So a judge takes a little bit longer than they ordinarily would if there were more judges available. So it's a number of factors that ultimately cause a delay. So that's why sometimes when we look at these things, yes, we must hold individual judges accountable, but we must also look at the systemic issues that cause the delays.
Yeah, some suggest that this is no excuse, essentially, especially when you take a look at some of the perks, which include lifetime perks. And so the suggestion that the Office of the Chief Justice needs to address this, and that's Raymond Zondo. Is that a fair assessment?
Yes, I think it's a fair assessment because a lot of these issues are not new. They didn't come up in the last 3 months or in the last year. They have been issues for a number of years. And like I said, we must absolutely hold individual judges accountable. So a judge must know that they must deliver a judgment within 3 months. Ideally, it should be less than that. And when they do so, they must know that there will be consequences. So that is non-negotiable. But we must also look at the systemic issues, like I said, and those are the things that will be addressed by the Office of the Chief Justice, which must look at, for example, the number of researchers allocated to the judges. They must look at the number of judges themselves, because we know that they are not enough. They must also look at the kind of administrative support that is given to the judges, because a hard-working judge may very well be tripped up by underperforming administrative function. And so those two things work in tandem. And the Office of the Chief Justice is squarely responsible for the administrative function, and that must be addressed as soon as possible.
Mbekezeli, before we let you go, here's a fun fact of the day. In fact, we can actually attribute this to the Mail and Guardian. So each week they've got this interesting section, Numbers of the Week. And today, a day after Africa Day, on this day, on the 26th of May in 1948, it's been 75 years since apartheid was instituted in South Africa and present-day Namibia. And there you see a picture of D.F. Malan, and he's holding that famous board at the time. And so when we speak about the judiciary and the relationship to the laws that were created at the time, how far have we come in redressing some of those laws, according to your assessment?
Well, I think generally we've come a long way. Our constitution has really marked a turning point in terms of our history. When you look at the kinds of traumas and sort of the laws that were in place during apartheid versus those that are in place now. But of course, there is a lingering apartheid legacy where some of the laws that are in place right now were from that. Just 2 weeks ago, there was an amendment that was proposed to the Black Administration Act, which was a law that was passed in the 1920s. And what that law meant is that if you were black, if you were married before 1994, your marriage regime was completely different from white people. And that still affects mainly black women to this day. And it's only been amended over the last 2 weeks. So there's still a lot of work to be done. And of course, the apartheid legacy is reproducing itself in terms of the kind of poverty and inequality we see in our society. And so what I can say is there's been a lot of progress, but there's still so much more that needs to be done.
Mbekezeli Benjamin, Research and Advocacy Officer at Judges Matter. Thank you very much for your time this afternoon.